SWAVOs virtually for a year. It was March in 2020 where we got those calls that we had to shut down kind of our large meetings. So thank you for sticking with us. I didn't know what to expect as we were going virtual, but I'm glad that we have made it and we've still been able to get together. So just a couple quick things. This meeting is going to be recorded. We host the meeting in our Google Drive. And so if you miss a portion of it, or if you want to go back and watch it, or if you say, hey, that was really great, and I want to share it with my coworkers, you always have access to that Google Drive. It now has a year's worth of fantastic trainings in it. So if you have new hires or volunteers that need some information or some hours to fill, we have a lot of content for you. So make sure you can utilize those. You can always send me or Maddie an email and you can have them, or in general, they're linked back to the agenda page, or they're sent to you in that email. And so we'll post those here. So we are going to record that. I just want to make sure that you say, you know, if you choose to participate or if you need to rename yourself, you can do that as well. Our presentation today, I am excited about this series. If you remember kind of back to June, we've been working on this trauma-informed and all the different stresses, the pandemic and criminal justice reform, and just a lot of different issues have come up during this time. And so we're continuing to build on that throughout this series. And we've partnered with OVC TTAC that will do the remaining 3 Thursdays after today to really build on collaboration between agencies. We're definitely doing more with less resources right now. And so we want to make sure that we are utilizing each other and what is out there as much as we can. So I've really been promoting the Utah Crime, and I'm going to say it always wrong, the Utah Council on Victims of Crime and Victims' Rights, because I feel like they are at the base of what every victim advocate should know, and that every victim should be aware of these rights that they have. And so we're still in the midst of the legislative session. So I really appreciate Heidi, Reed, and James coming to us today, because I know that they are some of the busiest people during this time. And so for them to take time out of their schedules, when I guarantee you they probably will have so many emails going back and forth, even as we're meeting about different bills and speaking to different legislators. So they do such tremendous work on behalf of victims here in Utah and have been doing it for a long time. And so I'm really honored to have them present to us today. So I'm going to turn the time over. I believe James is going to run the PowerPoint, and I'll let James, Reed, and Heidi just introduce a little bit about themselves before they get started.
James, you go first. Maybe not. I'll start off. My name is Reed Richards, and I'm an attorney practicing in Ogden. I've been working with the Council on Victims for many, many years. In fact, I think since it started. I'm about 3/4 retired now, but I've been the county attorney in Weber County. I was the chief deputy attorney general in the attorney general's office, and have done legal work for a number of cities and counties around the state, and still do a little bit of that. So this is an interesting area for me, and I'm glad to be with you.
Yeah, I'll kind of follow up with Reed. We're so fortunate to have Reed just 3/4 retired. I have never known anyone that is has such a bright mind and a creative person, and just good to the core. There's no one else like Reed Richards, and we're so glad to have him here today. And Heidi, I think you would agree with that. And he's pretty modest about all that he's done. He's done a lot for victims of crime in Utah, and he's done so much for his community locally. We could go on all day about Reed Richards, but he's just one of the most exceptional people that we could ever be associated with. So with that said, Heidi falls in that same categories. Heidi, do you want to introduce yourself?
Hello, Hello, and it's so fun to see so many familiar faces and to read the names and see new faces in our victim field. So I look forward to getting to know each of you better. My name is Heidi Nestel. I am the director of the Utah Crime Victims Legal Clinic. I am a former prosecutor for Davis County, and then 15 years ago started with the help of the Council for Victims of Crime, started this nonprofit legal clinic so that victims can have their own attorneys. Primarily in criminal court, we do also help with protective orders and stalking injunctions when legal aid or legal services are conflicted out. So we'll be talking a little bit more about the legal clinic today, and I would love to hear any of your questions about the services that we provide. But essentially there are 6 attorneys in our office and a victim advocate, and we're just very passionate about informing victims about their rights and helping them assert and enforce those rights.
Heidi's quite modest too. She's an attorney and has worked in Davis County for a number of years and is an ardent advocate. As you all know, you probably know her personally for victims. She is just, we're so lucky to have her, and the Crime Victims Legal Clinic, which is kind of your child, Heidi, right? You've been there from the beginning.
Well, that's what's so great about the council that we're going to talk about today. The council was really responsible for identifying that the Department of Justice was looking for 8 states to host a pilot program to see what it would look like if victims had their own attorney. So it's really the Victims Council that applied for the grant and brought that money to Utah. And then I was fortunate enough to be recruited to lead it. But I think being involved in the victim field, there are just so many organizations and people who are championing for victims of crime, and kind of just all partnering together. We've made amazing strides in helping victims' rights in Utah.
Thank you, Heidi. My name is James Swink. I'm currently the chair of the Utah Council on Victims of Crime, and I'm the Cache County attorney and have been doing this. We were talking in an admin meeting this morning in my office. I see Terrell's online, that my chief deputy's been doing this 25 years, and I know Terrell has, and I know that all you online don't do this for the money, but you do it out of a sense of not duty, but purpose. And we so appreciate the work that goes on with our victim advocates across the state. We could not do our jobs effectively as prosecuting attorneys, and victims would not be served without your help. So that's a little bit about us. We're so glad to have everyone online. I was actually a little slow getting on because I was going to share my screen, and hopefully I can find it. I may have to come back to that. Can you see that screen? I don't think you can.
No, we can't.
So let me just do this. I'll share this here.
We can see that one.
Excellent. Okay. So Heidi started out talking about the Utah Council on Victims of Crime, and Reed has been here from its inception. So Reed, we're going to let you start out and talk about the Utah Council on Victims of Crime and how it came about.
James, just really quick before we start, it wasn't there earlier, but on your PowerPoint that we can see now, it has 2 black bars. And I'm not sure if it will cut off any of the words, so.
Okay.
Is that something you can share the screen on and rather than James? Is that going to help?
I can. If it's not going to work for James, I can share it.
And it's still there?
Yes.
And it does cut off the words.
Yeah. So why don't I'll stop sharing, Rochelle, and let you kind of.
I'll take over. I'll get you to the history. Go ahead, Reed.
The council, well, before we start on the history, let me just talk, since James embarrassed both of us. James has been a really devoted victim advocate from the very beginning. He's been the Cache County attorney for a number of years. And it's nice to have an elected person as the head of our council, because they really are not subjected to pressures that sometimes come from people who are working for others that can tell them what to do. So that's given him the ability to be a little bit independent in his views. He's a wonderful prosecutor, a great attorney, a good administrator, and is a perfect choice for the chair of our council. The council is an interesting entity. It started out in about 1990. It came from the initiative that was started by President Reagan to look at victims' rights all across the country. And he assisted with that effort by pushing states to get involved. Governor Bangerter, who was the governor in Utah at the time, established initially what we called the Governor's Council on Victims of Crime. And it was set up directly under the governor and operated kind of using his authority for a number of years. And then eventually it was moved into statute. So now it is a statutory entity created by Utah state law. It falls kind of independently as a government entity, but the staffing and help support comes from the Office of Victims of Crime. So we technically are not involved necessarily in the operation of that entity, but they do provide wonderful support and help to the council. And so a lot of the contacts that you'll have with the council will come through them. The council really became a viable working entity when we had to try to get victims recognized in the state. And initially we had lots of trouble because every time we tried to do something on behalf of victims, we'd get the argument that
I believe
Reed's frozen.
Yep, I believe so as well. But you guys can't see the screen now, right? James or Heidi, do you want to try to pick up? And looks like James might be calling Reed.
Well, I think what Reed was saying was what we were finding is the council wasn't as effective as it could be, and victims weren't being heard because victims didn't formally have rights. And so that was one of the first agenda items of the council, was to look at what other states had done and find out what victims in Utah needed as far as rights. And so those efforts really started as early as 1987. But Utah passed its Crime Victims' Rights Act in 1994, as well as a really important constitutional amendment affording victims' rights. And that was really done at the effort and of the Victims Council to get those rights drafted, to meet with the appropriate partners, such as the prosecutors, the right legislators, and to promote victims' rights throughout the state so that it could be passed as a constitutional amendment. So Reed, were you able to rejoin?
This is why we love meeting in person.
Yes, you don't freeze in person. Reed's not on yet.
Okay,
yeah,
Michelle, if you want to advance a couple slides.
Yeah.
James, you want to go over the duties?
Yeah, there's really four, and we won't bore you. Stay right where you're at, Rochelle. The previous slide has the statutory language of what the Victims Council is statutorily obligated to do. And the first thing is that we make recommendations to the legislature, the governor, and the Judicial Council on victims issues. So we're a source of information for those groups. We interact with them. We serve on committees. We are constantly putting forward concerns and victims and things that we might be able to do to improve victim services and a victim's position in the criminal justice system. So that's one. The second thing that the council is charged to do is provide training on the rights of victims of crime. And we've got another slide where we'll go to that. And then third, consider any victims' rights committees, unresolved complaints, and then advocate the adoption, repeal, or modification of laws or proposed legislations in the interest of victims of crime. So Rochelle, if you can go to the next slide. I've already talked about making recommendations to those groups. So if you want to go to the next slide. Now training in Rochelle's position, and we're so glad to have her on with the OVC. The council, and is Reed back on yet?
Not yet.
We anticipated Reed doing all of this, so we're kind of sad he's not online, but we'll let him summarize. But we, as you're aware of, we do the annual Crime Victims Conference, which will be virtual this year. And Rochelle, do you want to throw out a advertisement for that real quick?
Sure. That's the Crime Victims Conference. As everyone knows, it was postponed last year. It was too soon to try to move it virtual, and there was too many unknowns. And so we tried really hard to move it to the fall, and it still wasn't safe in the fall. And so we moved it again, but it is going to happen now in 2021, but we're going to go virtual. The same topics that are going to be covered. We're having a couple national presenters come in, some really good breakout sessions. So if you've not registered, if you registered last year, it's carried forward. So you're already there. If you've not, registration is still open, and you can select your classes you want to join and join from the comfort of your home.
Thank you, Rochelle. We appreciate Rochelle's work. There's been quite a bit of work just on the venue itself, let alone keeping Ned Searle and Doug Fossen in line and the planning committee. We so appreciate her wonderful work. And Maddie, in fact, we need to throw a shout out to both of you. We appreciate, I don't know if Tally's on, we are supported by the Office of Victims of Crime, and the Victims Council could not carry on its work at all. Well, it'd be really limited. It'd be like prosecutors trying to do prosecutions without a victim advocate. It wouldn't go well. And we so appreciate all of your help. So, we look forward to the annual Crime Victims Conference. The district rights committees also do trainings on local levels. They'll get with local judges or their groups in the community. If there's complaints, we often go to individual departments or agencies and talk through issues with them. And it's an ongoing effort by the district rights committees around the state, which there are 8 of them. They follow the judicial districts. And they do training for those local districts. And then other training that we mentioned is now carried on by OVC, Victims Academy, and SWAVO training, which is going on today. And we've probably missed some others, but if Reed's back online, or Heidi, if you want to chime in here.
I think you've covered it well. I mean, I think training is so important because any one of us can only affect so many clients and people. But I think by sharing ideas and being proficiently trained, we get to just help so many more people.
James, you're muted.
Rochelle.
Well, I can certainly do it on the phone, but I don't know that others can hear me.
Yep, I have Reed now on the phone, and his internet went out. So this is complicating things since Reed has at least a third of this presentation or more.
Well, I'll keep working to see if I can get it back on. Otherwise, we can try to do it by phone.
Okay.
I don't know if there's a number I call other than just you. There probably is.
No, there's a Zoom number. I'll email it to you, Reed.
She'll, could you, Rochelle will email it if your internet's down.
You text it to me? Text it to me. That's going to be faster.
Yeah.
801-690-1457.
Yeah. Did you get that, Rochelle? Hey, we'll
so if you do that, at least I can be on audio, so that'll help.
Yep. All right. We'll look forward to getting you on, Reed.
Did you go on without me, hopefully?
Yes, we did. Okay. Talk to you real soon. Bye-bye. All right. So you probably overheard that conversation. Reed's internet went down, and so Rochelle's texting him a phone number so he can get in. Rochelle, Heidi, did you want to add anything on the training front?
No, I think you did a great job.
This has been going on for some time, and I remember the Victims Academy often took place in the early days up to Weber State, and there's been a lot of training over the years, and it's partly why our victim advocates are so wonderful, is because of the ongoing training, and they often train those that they work with, like the attorneys. So Rochelle, if you want to go to the next slide, we could move forward. So this has actually happened more in the last couple of years than ever before. The victims' rights committees, which you're aware of, are around the state, will hear victim complaints. And some of those don't resolve. There are conflicts or other problems in the local districts where sometimes they'll make their way to the Council on Victims of Crime. And we've heard a couple of those in the last year. And we're in the middle of one right now where we're helping a couple of victims through a process where they feel like that their rights have been violated. And we're working with those who've been complained against and trying to make improvements to the system, and also assist those victims in making sure they're heard and that their concerns are getting resolved. So right now, Heidi's actually serving on that committee, and Reed, and there are several others on the Victims Council that are currently hearing a current victim complaint. So that's one of the other duties that the council is charged with. So the next slide, Rochelle. And this will be a wonderful segue into our discussion on legislation. But the Victims Council, this is the language from the statute. It says, shall advocate the adoption, repeal, or modification of laws or proposed legislation in the interests of victims of crime. And Reed, I was hoping he was online. Did you get on, Reed? Not yet.
There, I think I'm back.
Oh, you are back. Just in time. So Reed, why don't we, we'll bring you up to date. We've talked about, Rochelle, if you can just go back to the slides and we'll just show Reed where we've been. We've one more and one more. So we've gone over, go ahead and go forward, the statutory duties of making recommendations to the Governor, Judicial Council on victims issues, and the legislature. And the next slide, we've talked about training, and talked about all those things we talked about earlier this week. And Rochelle put a nice plug in for the annual Crime Victims Conference that will be virtual this year. And now it takes us to the next slide. And we've talked about the subcommittee that's has been hearing a current complaint and that has heard other complaints in the past. And so finally, Reed, you're right on time. We'll have you take over this last slide.
Okay, well, we were talking before I got kicked off my internet about being involved in the constitutional amendments. The first one was on the rights to keep people in jail and not let them out on bail. The second one, though, was the big victims' rights constitutional amendment that provided a massive bunch of rights for victims. And that is still in the Utah Constitution, and it's supported by lengthy statutes that back all of it up. So most of what victim advocates do came into being back in that 1994 constitutional amendment and the statutes that tied into the amendment. So that's been an important part of what we do. It does give us the power of the Constitution to back up the rights of victims rather than just relying on statutory law that tends to change periodically. Over the years, the council has been involved in literally hundreds of changes in the law involving victims. Some years are busier than others, but in most years, we've sponsored many, many bills and also supported and fought many, many bills. And that really is just as important a role as passing bills, making sure that ones that are detrimental to victims don't pass. And we had to do a lot of that this year. So that's a continuing effort and one that we need help from all fronts on. So any of you that have experience in some of the areas where we're trying to pass something or trying to stop something from passing, those experiences are very, very helpful in making the case to the legislature. We also get involved in court rules. A lot of times the court rules dictate what information can come in to be heard by a jury or a judge at the trial. For example, one that we're involved in right now is involving what prior sex acts would be admissible in a rape trial. Currently, it's very restricted in Utah, and we're trying to change the rules here so that it's more like the federal rule, which allows prior sexual violations to come in as evidence on a current rape case. So rule changes are also an important part of the work that we do. We try to monitor all the new rules that come into effect that affect victims and try to make sure that the victim's voice is heard. And sometimes we'll actually make a request that a court rule change be made on behalf of a victim. One notable one was the Rape Shield rule that now is part of the court rules relating to what prior sexual activity of a rape victim can come into court in a court case. So that's an important area as well. And then appeals. We've also been quite involved over the years in appeals that go to the Utah Supreme Court involving victims' issues. The most recent one was last year, the Lopez case that the council was involved in. Heidi did a lot of the work on that, or Heidi's office.
Darn it, I think he froze again.
Reed and I only live about 1.5 miles away from each other. I need to invite him over.
Yeah, I'll try to get him back on the phone. Heidi, do you want to talk about that Lopez decision and the—
Yeah, I'll just pick up the discussion there, but one of the main issues that we've been fighting for about 5 years is trying to challenge defense attorneys who want to compel victims to testify at the preliminary hearing stage. As I'm sure all of you know, victims do have to testify at trial, primarily because the defendant has a Sixth Amendment right to confront witnesses at trial. But that does not apply to earlier hearings like preliminary hearings. And in 1995, we actually passed protections in our state constitution to allow reliable hearsay so victims wouldn't have to testify. Anyway, for the last 5 or more years, defense attorneys have been subpoenaing victims. So we ended up taking 2 cases up to the Utah Supreme Court, State versus Hernandez out of Utah County, which in the end, the defense had improperly appealed it. So we didn't get a decision in that case. And then most recently, State versus Lopez, which we argued a year ago, last April, and got a decision in August that the Supreme Court ruled in favor of victims not having to testify at preliminary hearings. So that was a great victory. And my office, we were representing the victim in the Lopez case at the district court level. We fought that issue, we brought the appeal. But what the council did, and I realize it's kind of hard to keep all these victim names straight, but what the council did was file a memorandum in support of the victim's position. And I really do think that that added a lot of weight and gave the Supreme Court even more to think about on the issue. But that's just one example. And just to link around to James talking about the victim's rights complaint process, I really want to promote and ask all of you advocates throughout the state to know about that option for victims. Most of the cases that we've taken to the Utah Supreme Court have come through complaints made at the local victim committee level. So they make a complaint, and then oftentimes our office will get involved to help the victim, and it's translated into several legal issues being brought in front of the Utah Supreme Court. So that's a really important process and a good option for victims if they feel their rights are not being protected. James, you're muted.
Yeah, thanks, Heidi. You talked earlier, that's an excellent explanation of the appeals and the part the council plays in that. And Heidi's office has been tremendous to work with Paul Cassell and other folks in getting those pulled together. But and you mentioned earlier, Heidi, about the Crime Victims Legal Clinic and the wonderful work that they do. Do you want to follow up with that?
Just to keep us in mind, not every victim needs their own attorney. In so many cases, prosecutors across the state are enlightened on victims' rights and protective of those rights. The Utah Crime Victim Legal Clinic gets involved when maybe victims have a different interest from the state. So either they may be on a different page as far as what a fair resolution to the case might be. Victims want to maybe speed the process up, and so they want their own advocate to assert their speedy trial rights. A lot of the work that we do is to protect victim privacy, either their records, their cell phones from being subpoenaed and downloaded. And those aren't necessarily issues that prosecutors would fight. So if you have a victim that you're working with who either needs additional support or advocacy in the criminal justice process, that's when we would ask for you to refer a case to us.
Excellent. And as we talk about these resources for victims, the Crime Victims Legal Clinic is a really specialized place to go. And they're so helpful on really important issues. The local district rights committees, and Rochelle was going to send out materials with the membership of the Crime Victims Council. And on that, you'll notice there are 8 district rights committee chair, and each of you should know them and should be really, you should have their cell phone, quite frankly. And if you have issues that need to be addressed before the Crime Victims Council, you're always welcome to get a hold of Reed or Heidi or myself or other members of the council. But those people are local folks, and they sit on the council, and you have a relationship with them most likely, and continue to develop that. And if there are issues that you think need to come before the council, get a hold of one of us, and we'll get those things on our agenda. And that's, this is not an organization where it's top down and everything is issued from the Council on Victims of Crime, but it actually comes from those that we work with, the victims themselves, and those that work with victims. And that's really where a lot of these issues, like Heidi just mentioned, come forward, is from all of you. So we want to thank you for that, and just remind you that if you have issues that you see that need to be addressed with the Judicial Council or the governor or the legislature, like we've been talking about, bring those forward, and we will address those and get those on council meeting agendas. Do we have?
I'm just going to jump in really quick and let people know I just linked the Google Drive in the chat, so you can access the roster for the council, the legislative tracking that we're going to be looking at a little bit later, their bios and things like that.
Well, are there any questions to this point? Well, let's, Rochelle, if you want to go to the next slide. I have Heidi's name on this, but I actually, Heidi, I have an updated presentation, but this was mine if you want me to talk about it. This is one that I mislabeled. There was only one, but this is it.
Yeah, I was planning on you doing that. Thanks, James.
Okay. So let me see. Well, we tried to get Reed back online. Rochelle, I'm going to try to stop your sharing. Is that okay for just a second? And Reed's calling, so give me just 1 second. Okay, I have an update on Reed's disappearance. Reed is, he is going to head down to his law office and jump on. So Heidi and I will charge through a few bills. We'll skip some of Reed's and we'll circle back around those. And I'm going to try to share my screen again. Is that any better, Rochelle?
Go into the present. I still see a bar, but let's see.
Yeah.
I was chatting with our resident expert, Maddie, and she says it has something to do with the format in your Zoom. So if you want, we can go back to sharing.
Yep, we better do that. Let me do one thing real quick. This is apropos if I can share it. Okay, can you see that screen okay?
Yes.
Okay, and hopefully this sound.
Oh, I wish Maddie was wearing her shirt. The sound's not working though.
Okay. So the sound isn't working.
I'm pretty sure my office has it memorized if you just want us to act it out. Ready, Maddie?
You ready?
Just kidding.
We'll share it another time. It's a classic.
I'm ready to move forward. I'm not a cat. I'm live.
This is really worth seeing.
James, I'll find it and put it in the chat.
Hey, that would be awesome. Okay, Rochelle, if you want to roll us back to the bills, and I'll start with Representative Elison's House Bill 20. So this is a bill that imposes enhanced penalties for individuals that have a blood alcohol level of 0.16, or they have a blood alcohol of 0.05 and they have a controlled substance on board, or 2 or more controlled substances on board. So this raises the penalty from 48 hours to actually 5 days mandatory minimum jail on an offense. It still doesn't sound like a lot, does it, for someone that's putting people's lives at risk? There's also another provision that not only 5 days, but if they do 48 hours of jail, then they would have no fewer than 30 days of home confinement with a monitor that actually tests for controlled substances like alcohol or substance abuse. So there are those ankle monitors that monitor for alcohol. So in those instances, they could be given the 2 days jail and then 30 days home confinement. But that is an increased penalty, and that bill has passed. Some of these bills that we talk about today, we just don't know. Many of the bills that we'll be talking about and that are still going through the legislative session won't pass until tonight. It's usually the last day or two of the session, many of the bills passed. In fact, there were 4 or 5 that we added to the presentation today that had passed that we were unaware of last night as we were brushing up this presentation. So that's the DUI sentencing amendment from Representative Elison, and I'll talk about another bill that kind of came out of Cache County a little bit later on. So the next bill.
And we're just going in order in sequence that they were numbered, but Reed had mentioned that one of the important roles of the council, and I'm sure some of you have experienced roles as an advocate, is to talk about legislation that might be bad for victims. And House Bill 21 sought to amend the stalking statute in a way that my office and the council, and I think a lot of victim communities, thought would be harmful to stalking victims. Essentially, and so we're going to talk about a few things that didn't pass, not to confuse you, but just to understand kind of what efforts are being made out there and what kind of issues as advocates we need to be aware of. So this House Bill 21, the 2 main changes that it was proposing was right now, in order to prove stalking, I'm sure you know, there have to be 2 or more instances that make up a course of conduct. What this new bill proposed to do was to change that to 3. So those of you who work in stalking, like my office does, you know, oftentimes the victim, there's a flurry of activity that the victim feels is going on, suspects is going on, maybe even knows their stalker is doing. But to actually be able to prove them oftentimes is a challenge, even just being able to prove 2 stalking instances. This would have increased that by 1/3, meaning we'd have to prove 3. Eventually, in a substitute bill, the sponsor was willing to take that out and leave it at 2, but was still trying to pass the bill on the second provision. And that is that the victim would have to show that there was a continuity of purpose. Essentially that there was no break in time or episode of these different stalking instances. We were really concerned about this one because I thought it was very vague and an ambiguous wording, to the point where I felt we could get a whole different types of interpretations from judges what continuity of purpose would mean. And I was really fearful that victims would not be able to get stalking injunctions in Utah based on whether it was 3 instances or having this continuity of purpose. So anyway, the victim advocate community rallied. I know Alex from my office was very involved. She was interviewed by many news sources. I believe a couple of dozen advocates got together and signed a letter opposing this statute. And eventually, I believe the sponsor decided to hold it, and it didn't go any further. So this year it did not pass, but it is an issue that's on the radar now that we need to continue to advocate for stalking victims. Because my experience is it's already very difficult for stalking victims to either get an injunction or to prove as a prosecutor a criminal case. So I think it's sufficiently difficult right now, and hopefully we won't get any more obstacles to stalking victims getting protection.
That's wonderful, Heidi. Thank you. And this is a real kudo to all of those victim advocates that spoke up. You are a powerful lobbying group, just so you know. People listen to you, you're legislators, and when there's important bills, your efforts really make a huge difference, and this is a good example of that. We talked until we were red in the face and only got it reduced to take out the 3 episodes, that increase. But because of the work of other folks and contributions, that bill was turned around and was held. So it's just a good example of the efforts that you've made that are really beneficial to us. Rochelle, if we want to go to the next bill. So these are DUI revisions that basically we had a terrible up here in Logan Canyon. We had 4 teenagers, and you may be aware of this. One of them's a senior in high school. She's a cheerleader, and she's now a paralyzed cheerleader. She's moving on with her life. She's quite resilient.
She's actually a double amputee and paralyzed.
Yeah, just an awful DUI that occurred up here. These folks, the parents of these victims, are great people, and we're close to getting a resolution on the case and bringing some closure to the victims. But this defendant was out before the kids were out of the hospital the next morning. Some of them were admitted, and some stayed for quite a while, actually. But he was not held by a judge and inflicted serious bodily injury on other people. And that's what this bill does. This is Representative Elison's bill. A shout out to him. But this allows for the denial of bail for DUIs, much like we are getting for domestic violence victims. This would fall in that same category. So that allows for denial of bail when they've driven under the influence of alcohol or drugs and there's serious bodily injury or death. So we'll be seeking that. That's been a gap in our bail reform, and we'll look forward to closing that gap. It also creates a presumption that such cases present substantial danger to the community, And it also provides that the victim is not required at the bail hearing if it would present an undue burden on the victim. So it's a victim-friendly bill, and we appreciate Representative Elison's work in that. And Terrell, did you want to add anything? I know Terrell's been in touch with Representative Elison about this bill and the case.
No, I just hope that this will help future cases to where we don't have families, and we're not as victim advocates trying to explain why somebody is out when their child is fighting for her life. And at that point, we didn't even think she was going to live. So I hope this will help.
Thank you, Terrell. The next slide, Rochelle. This is Reed's. We'll come back to it. That might be a familiar scene. That was Salt Lake and the riot that took place, but we'll come back and let Reed talk about the riot amendments. And Reed also has this one. And Heidi, to you.
Thank you. For any of you who work in the juvenile court or work in the adult court system where you have someone who is already under jurisdiction of the juvenile court, but then also either because they've been certified or find themselves under the jurisdiction of the adult court. So these are for cases where the same defendant is under the jurisdiction of both the juvenile and the district court. What this amendment does is just establish some procedures about when the district court judge should consider either issuing concurrent or consecutive sentencing. So if the defendant or juvenile is already under the jurisdiction of the juvenile court and has some disposition requirements, either they're in detention, secure facility, doing some other conditions, then the district court can consider what the individual is having to do for the juvenile court to decide whether the district court sentence will be run concurrently or consecutively. So it kind of just is for that narrow category of where someone finds themselves in dual jurisdiction of the juvenile and the district court.
That's excellent, Heidi. I just wanted to kind of put the car in reverse and talk about the DUI bill again, and just kind of get this out there for all of you. I hope you can support this next year. We believe that if someone inflicts serious bodily injury on another person, it shouldn't be a third-degree felony. It ought to be a second-degree felony. It just does not make sense that that it's such a low offense. And so we're going to be running a bill next year to, if there's serious bodily injury inflicted on another person, that it would be a second-degree felony. And why that is important, and all of you probably know this, but the sentencing matrix is so skewed now that the presumption is 12 months for a third-degree felony where, for instance, this gal lost her legs in an accident, and the presumption is 12 months incarceration. That's the presumption. And we believe it should actually be, there ought to be more on the table at that point. And in this case, there were 4 children in a car, and 3 of them received serious bodily injury. One's injuries were not as serious as the others, and we have a Class A misdemeanor, but all we're left with in the end are these third-degree felony DUIs where the presumption is 12 months of incarceration. And so it just seems inequitable. The families, again, who were parents of those children who were in that serious DUI accident, will be assisting with that bill next year. So just kind of a preview for next year. Thanks for entertaining that, Rochelle. We can move forward to HB 78.
So this, unfortunately, was a bill that did not pass, that in the victim community we were advocating for. Any of you who work with sexual assault victims, rape victims, know how difficult those cases are and how underreported and prosecuted they are. So the consent amendment sponsored by Representative Romero, and really advocated for by the council. We were working with Paul Cassell and Julie Valentine, who surveyed the entire nation, had great research to back up the fact that there was a gap in our law as far as prosecuting rape cases. So currently the standard or the law requires that not only does the victim not consent, but that the defendant knows they're not consenting. And that has just been a very difficult standard that has deterred a lot of cases from being, from criminal charges being filed. So the consent amendments law was meant to fill that gap and essentially require an affirmative consent from a victim, either by expressed words or overt actions that the victim would, have to, there'd have to be some evidence that the victim affirmatively consented. Otherwise, without that affirmative consent, if someone continued to engage in the sexual activity against that affirmative consent, then that would be a third-degree felony. So these are called affirmative consent laws. There are the majority of states in the United States have adopted them. Obviously, it's a third-degree felony, so it's not at the same level as a rape case, which is a first-degree felony. But we really felt that it would increase the likelihood of sexual assaults being prosecuted in Utah. This was highly contested at the legislature. If any of you tuned in or testified at the committee hearing meetings, there were obviously a lot of defense attorneys speaking against this new law and a lot of victim advocate groups speaking in favor of it. Unfortunately, it narrowly did not pass out of committee. This is something that we still feel that Utah needs, and I suspect something that we will be advocating for in the future.
And
hey Heidi, in the chat, there was a question saying, why would someone oppose passing this bill? Can you kind of say what the defense was going after?
Well, I think the defense knows that, that this bill will translate into a lot of people being prosecuted for sexual assault. Because now we won't be looking at, the defendant has always been able to say, well, I didn't know she wasn't consenting or he wasn't consenting, and it's often turned on the defendant just saying, I thought it was consensual. And now that there would have to be, the defendant would have to, it wouldn't matter under this new law what the defendant knew. They would really rely on the victim's testimony of whether they gave affirmative consent or not. So we believe that this would exponentially raise the number of sexual assault cases that would be filed. And of course, defense attorneys don't want that. Because right now, only 6% on average throughout the state of cases even get filed, reported cases get filed. And so defense attorneys want to keep that number low.
Yeah, and of course, if the defense doesn't like it, we probably ought to look at it and go, it might be a really good thing for victims, which it is. And next year, when this goes through, we'll need the help of everyone. We need everyone to get behind this effort. And if we get working on it early, we'll have a much better chance next year of getting this through the legislature. I think we have Reed Richards back.
I think I'm here now. I'm sorry. My home internet just went kaput, and so I had to run down to the office. So you want me to pick up the two we've passed that I was going to do?
Yes.
So
I just want to say, this is the kind of dedication that Reed has dedicated. If it would have been me, I would have said, sorry, James, Heidi, you guys got this. But look at this guy getting in his car, driving to his office. Thank you, Reed.
They'd have probably done a better job than me anyway. So anyway, House Bill 58 is really the response to all of the riots that took place across the country this last year. And the picture depicts what happened in Salt Lake City, the police car that was rolled over and people jumping on top of it. So the legislature, as they always do, reacts to things that happen in the state. And that's kind of a good guide to remember. if you have a significant case that you found deficiencies in the law, those often will be the things that instigate changes. This makes rioting a felony if there is significant bodily injury, significant property damage, or if there's a weapon involved. And a weapon doesn't have to be a gun. It can be a frozen bottle of water. If any of those are involved, then the person can be charged with felony level rioting. If that happens, they cannot be released from jail without first going in front of a judge and pleading their case. And secondly, they can't get out on bail if they appear to be a danger to the community. So those are interesting changes. It also took out of the definition of rioting tumultuous conduct because no one knew what it meant. So we took that out. So that's a nice change. The next one is House Bill 60, carrying concealed weapon. This one is probably not real positive for victims. As you probably know, the gun lobby in Utah is very strong, and therefore it's been a challenge to restrict the use of firearms in any way. And for many years, we required if you wanted to carry a concealed weapon, in other words, a weapon that you can't see, you had to get a permit to do that. About 10 years ago, they changed that so that pretty much anybody could get a permit. This year, they changed it again and said, we don't think you even need a permit. Anyone who is legally able to possess a weapon can now carry that weapon concealed, not only in their home and their car, but also on their person. This shows in the picture in the purse, in the coat pocket, wherever you want, it can be concealed as long as you're legally entitled to carry a weapon. Okay, let's move on.
So in this statute, and Reed, I think you messaged us today that House Bill 59 passed as well. And we skipped over that, but I can talk about both of them together. So House Bill 59 was titled Intimate Image Distribution Prohibition Revisions. And Reed, is that accurate that 59 passed?
Yes. Yesterday.
And that's similar to House Bill 147, which is called the Revenge Porn Amendments. So in House Bill 59, it specifically addresses when, intimate, sensitive, what would be classified as pornographic images are given to law enforcement for purpose of investigation, that this law specifically talks about that those images cannot be shown, displayed, or distributed unless there's a criminal justice purpose. So this was specifically to address the Lauren McCluskey situation on the U of U campus. And just to make sure that if these images are discovered as part of an investigation, or if a victim supplies these to aid an investigation, that those images need to be protected, that they can't be shown, displayed, or distributed without there being an investigative purpose. Otherwise, there can be a consequence for whoever is doing that. In House Bill 147.
And Heidi, by the way, that hasn't quite passed yet. It's still in the Senate on final hearing.
Okay, we're anticipating it to pass. It's a little tricky doing this right at the end of the legislature because, as James said, the majority of these bills, it's such a lengthy process to get legislation passed, but legislators are highly motivated the last couple of days to pass a lot of the legislation. So we might be giving some updates at the next opportunity, SWAVO opportunity or training opportunity. But House Bill 147, which is here on the screen, this has passed, and these are the revenge porn amendments. Fortunately, a couple of years ago, we got this revenge porn statute passed that makes it illegal for someone to post or distribute intimate images against the victim's consent. And what this does is this specifically removes the requirement that the prosecutor demonstrate that the victim had actual emotional distress or harm as a result of that distribution for very specific cases. or situations. And so there are essentially 4 conditions that have to be met. But if we are able to meet them, then the prosecutor doesn't have the burden of actually having the victim demonstrate that they've had emotional distress or harm because of the distribution of those intimate images. So just briefly, the 4 conditions of that is the image has to be of the victim. Number 2, the intimate image has to have been provided to law enforcement as part of an investigation. Number 3, that the image was distributed without a law enforcement purpose or consent of the victim, and that the victim is either incapacitated or deceased. So it's a kind of a very unique set of circumstances. But if those exist, then we're alleviated from having to prove that the victim was emotionally distressed because of it.
Heidi, can you see in the chat, there was a question about the concealed permit bill?
Okay. What's the question?
The question was, can the concealed weapon be loaded? Or is there a number of actions that are still needed?
Nope, doesn't matter.
Can be loaded
there is no
as well?
No rule now against carrying concealed weapons, so you can carry it however.
That is a concern for folks, right? I grew up with guns all around. I'm not a big gun person, but we know that their role in domestic violence deaths is the major role. That if there's a gun that is owned by the partner in a domestic violence situation, that's the biggest risk factor that someone will be harmed or killed. So it's a huge issue for victims, I think. But the governor, that's been signed and has been enrolled already. So that's the law.
There was one more question and says, does it have to be concealed or can someone carry it on their hip without in just a holster? But I think it's always been able to be in plain view, right?
Yeah, open carry has always been permissible with one limitation. If you go to a place that's crowded like a mall and you're causing a huge disruption, then there are abilities to make you put it away or even charge you, but that's the rare exception.
That's a really good question.
Okay, 158.
Forward.
One more question about open or concealed carry. They're both available now. People can carry openly and with concealed weapons.
There was another question it looked like about whether you still have to do a records check to buy a weapon, and that is true. That hasn't changed. You still have to have a records check, and if you are on the restricted list, which in Utah mainly means you've been convicted of a felony, you cannot purchase a weapon, and you can't carry a concealed weapon either.
So thank you, Reed. This next picture is something, I was a big juvenile delinquent. I know that's hard to believe, but I was charged with trespassing. I was on the back of a four-wheeler as a youth and got hauled into juvenile court. And I also got a ticket on a motorcycle when I was about 13. I wasn't supposed to be riding on city streets. So I identify with the little boy in the yellow shirt and being interrogated. But this bill is interesting. I've had really mixed feelings about this, quite frankly, on the side of we should let our youth talk to law enforcement. And this bill basically prevents law enforcement from being able to question or interrogate a minor or so a child under the age of 18 without having a parent or a friendly adult first giving permission for that questioning. I probably, I may not have gone to juvenile court if this bill had been in place when I was a kid. But with that said, there are exceptions if you're an emancipated child, someone who's gone to court and been emancipated from their parents and are now independent from their parents, or a juvenile who says they are 18, they represent their 18 years of age and the officer relies on that, or the law enforcement officer has been unable to make contact with the parent within 1 hour after the child is in custody. They can then interview the child. But this is an issue. We have we have youth who actually drive cars now, and maybe, and I know there was a basketball star at Mountain Crest this year that got a DUI. And of course, he was taken into custody. The law enforcement couldn't interview that person now without permission from the parents. And I think that has implications for victims of crime. We want to solve crimes. And quite frankly, we want youth to realize, and the system is different than the adult system, that they should cooperate with law enforcement and be good citizens. So this kind of unravels that a little bit, in my opinion. And you can see where I lie, that we ought to let law enforcement do their job and get to the bottom of crimes where juveniles are involved without having to go through extra steps and time, when time may be very well of the essence. And we need to be getting down to the bottom of an issue so other people may not be hurt. But that's the bill. So if your children are now pulled over or talked with law enforcement, they have an obligation to call you and get your permission before your child talks with law enforcement. Some people like that.
Uh, 193 may not pass in light of some of the other provisions that we've talked about with intimate images, but it is through the House and partway through the Senate. So we'll talk about it and see if it passes. Basically, it creates an offense of unlawful distribution of an intimate image. And that means basically if you distribute it without the consent of the person that's depicted, you've committed a crime. First offense is a Class A. Second offense would be a felony. If it's a child who's depicted, and they usually can't give consent even if they wanted to, it becomes a third-degree felony on the first offense and a second-degree felony on the second offense. So pretty logical. People shouldn't be sending out intimate images of people without their consent.
Sorry, I missed. Oh, there was one question in the chat, and I think it has to do with the juvenile. Would that be the case in a traffic stop? Would they have to talk to the parents? For
only when they're
stop?
In custody, so it would not apply.
Oh, only in custody, great.
House Bill 200 is, I don't know whether it's even worth talking about. It's a goofy little bill. The original idea when this concept was introduced a number of years ago was that if a cohabitant, somebody living in the same home, was afraid that the person living with them was going to hurt themselves or others with a gun, that cohabitant could take that gun to a police department or a sheriff's office, and they would store that gun for at least 30 days, kind of a cooling off period. And as passed, it made a whole lot of sense, and I think possibly would have worked well. But almost immediately in the next session, they came back and said, well, that's only true, but you're going to have to let the person who owns the gun come in and reclaim it anytime they want, which made it so that it didn't make a whole lot of sense to take it in, and then they can go back and pick it up a few minutes later. All it might do in a domestic violence case is make the person more angry than he was before and might generate additional problems. So, so this time they've just tweaked that a little bit and said that the person himself can take it in and turn it in, and the police can hold it. But again, if he wants it back, he can go get it back anytime he wants. So if a person feels like they're a danger to themselves, they might commit suicide, or maybe to someone else, they could take their gun to a police station, and the police department would hold that gun for them until they wanted it back. Kind of makes the police department a storage facility for people. I don't think it'll work, but that's what they've done. And it'll probably pass.
Well, this is a bill that's probably consumed more time of more legislators, defense attorneys, prosecutors. Victims have been involved with this somewhat, but it's bail reform. And there has been testimony from victims who have jumped online and testified for and against some of these bills. There are a number of issues rolling through this. And Reed, do you want to address those, or Heidi?
Well, the background is that last year we passed a bill that provided a great deal of bail reform. The concept has been, and it's probably a legitimate concept, that a person shouldn't be held in jail just because they're poor. So the idea of having people released on bail because they can afford to pay the bail maybe didn't make a lot of sense. Instead, that decision ought to be based on whether that person is likely to flee the jurisdiction or whether they're likely to commit other crimes or likely to be a danger to themselves or to other people. So that's what they tried to do last year. The problem is they went too far. And what we found is that pretty much everybody's getting out of jail pending trial. Now that's clouded a little bit because this last year we've been dealing with COVID in county jails. Which means that they've done their very best to get everybody out because they didn't want to have a COVID outbreak in their jail because that just creates all sorts of issues for them and for the inmates. So this last year really probably wasn't a good period to look at in terms of when people are getting out and when they're not. But that's all we have. And so because way too many people were getting out and not being held for potentially dangerous situations, they went back and took many of those requirements out. We think 220 will be the bill that ultimately will pass. The other two seem to be on hold. And if it does pass, it will eliminate most of last year's requirements, but we'll still have a few things there. So rather than get into details until we know exactly what's going to happen, I hesitate really to go into too much detail, James.
Yeah. There's a question online. Reed, that's wonderful background to this bill. It did pass out of the Senate yesterday, but there were floor amendments and I couldn't see those. Marcy, you've asked that question online. It passed out. I couldn't find the revisions.
I'm at legislation right now and it did pass about an hour, 2 hours ago. It's passed.
Okay. Yeah.
220?
Yep, 220. And there were some amendments made on the Senate floor and I could not find those. I looked this morning actually, and if you have those, I didn't want to speak to the bill until I knew exactly what had been shoved into it, but I couldn't see that this morning.
I think I can find those, and as soon as I do that, I'll share it in the chat.
Okay. The worry from victims on this that was expressed as they testified was that we are able to keep domestic violence offenders in more readily. And I think that's true across the state. We've made motions for detention. We wanted to be able to do that. I still believe we'll be able to do that. So as victim advocates, if we have dangerous people, the judges have gotten into a good habit of looking at these motions for detention, and I encourage the attorneys to keep doing that. I don't know that we lose that with the passage of 220.
We won't though. We really won't, because there are 4 different recommendations. Heidi could probably speak to this. Domestic violence, previous on probation. There's 4 different things, but they do allow for victims of domestic violence still to be protected. But what we have to do is work with our law enforcement agencies and our jails so that they know what to put in those PC statements. And we know they keep those PC statements super short and small because of media. We get that. So we have to work locally to make sure that they understand, what needs to be in those statements. Because like talking to our judge here, as long as we identify, or we have a way, we have that, hopefully a coordinated response to identify those 4 different things, then we can still protect our victims. But yeah, this is an interesting one. And, I see both sides, I get it, but yeah, we're gonna have to watch this one. And I'm not sure of the changes, the amendments. So I'm gonna look into that. Yeah, just past today, it kept changing and there were like 3 different bills all addressing the same thing. It got complicated. So I'll share what I have, but yeah.
Yes.
Maybe just a general view on bail might help as well. Bail generally is allowed on any misdemeanor case except domestic violence. And a bail can be denied on domestic violence, and it can be denied on any felony for danger issues or for failure to appear possibilities. So domestic violence really is the only major exception, and now rioting, I guess, for denying bail. And a judge then is going to have to make that decision. Now, what that means is that if you don't require mandatory bail for misdemeanors, most people are going to get out on any misdemeanor charge that's not a domestic violence without posting any bail.
Unless, and we talked about this while you were off, Reed, commuting back to your law office, DUIs where there's been serious bodily injury now is added to that list.
I just jump in with one really quick little thing that we should probably address. Like, what about when they don't identify the predominant aggressor and our victim is charged instead of the perpetrator? And then the victim has absolutely no income. They have no control over anything. And they can't pay that. It's only $20 to bail out. They can't pay that $20 to get out because the perpetrator controls everything. So I think we really need to address, like, you know, and I know there are definitely some problems when we can't serve a victim who's been charged with a crime. So identifying the predominant aggressor actually becomes even more important with this bill, because our victims sometimes are going to be jailed and they can't get out. They can't get $20 because they have no control over finances. So anyway, we have some work to do with this one. So it'll be fun.
That's a good point, Marcy. And it's an ongoing training issue too, isn't it, with law enforcement? You've made a couple of very good points about the PC statement, identifying the predominant aggressor and making sure that's clearly set forth and not arresting folks who are, quite frankly, the object of control and domestic violence. Those are very good points. Rochelle, we'll have to come back to this and update it. Once the dust settles, we'll be able to figure out everything that's been added or taken away from that bill. Again, these things are moving quite fast right now, but stay tuned. The good things that came out of 206 are that we got judges at least going along with us on DV cases. It was problematic for other crimes because there was language in the 206 that talked about the judge has to release people on the least restrictive means possible. Judges, I know in the first district, are releasing, they believe that at least one particular judge believes that requires her to release everyone that comes before on a least restrictive means basis, which isn't quite right. But anyway, so we're hopefully this will, as it moves forward, there will be a working group. Representative Schultz has included victims in a working group and other interested stakeholders. So we'll be doing our best, Marcy, to address those concerns and make sure victims are watched out for in this new bill. There'll undoubtedly be a bill next year that will come back before the legislature on bail reform. Yeah.
227 is not yet passed. It did go back on the second reading calendar today, so it probably will pass, but it hasn't quite passed yet. It's an interesting bill. It requires that if the defendant in a case is claiming self-defense, then you have to have a separate hearing prior to the trial to determine whether self-defense exists or not. And the state has to prove that it does not exist by clear and convincing evidence. And if they cannot do that, then the case is dismissed. So it will mean that some of these cases will be dismissed prior to going to trial. Now, if the victim is the domestic violence person, the person being abused, and if that person is charged with a crime as well, then it may be an advantage. But for the most part, it's probably not a great thing. Fortunately, the sponsor, with a lot of pushing from James and Heidi and others, restricted the bill to apply only in felony cases and in misdemeanor cases that do not involve domestic violence. So domestic violence is excluded, and it applies in other cases and felony cases. So we'll see where that goes.
And Marcy, just to clarify, you've written a question. What is the projection for this one? Do you mean whether it will pass or not?
Oops, there we go. Yeah, I haven't heard on this one for a minute. So I was just curious if you all had heard. I'm up here at the state capitol. I'm actually in the bathroom. Hello from my Zoom. I know.
I don't know whether we can talk to you in the bathroom or not. There may be some kind of a violation.
It's a nice room. There's two. All right. Sorry about that. No, I hadn't heard on this one if it's I hadn't heard on this one for a minute. I just wondered if someone else knew what the projection was like.
Well, it passed the House.
Oh, it did.
And it passed the Senate committee. Oh, and wow. Then yesterday they wiped the board clean, which means they took all of the bills that were in front of the Senate for second reading off and put it in rules. But today it came back up, which tends to indicate to me that they're likely to pass it.
Yeah, I didn't think it was going to come back up. Oh, interesting. Oh my goodness, interesting. Okay, tell us about it. Sorry.
Okay, well, basically it says that you have to hold these hearings for a claim of self-defense in all cases except B and C misdemeanors and domestic violence cases. So if it's a case that's Class A misdemeanor, not domestic violence, or a felony, not domestic violence, if the person is claiming self-defense, you have to have this pre-hearing to determine whether it exists or not. And in order to continue with the case, the state has to prove by clear and convincing evidence that self-defense does not apply.
So we have over 100 participants on today. I kind of have a plea to everyone, and we're gonna go out and talk to prosecutors as well. We really wanna monitor this bill over the next year to see how many cases we're noticing defendants are making claims of self-defense and pushing for this hearing. Our concern with domestic violence victims especially is that now that we've won these battles to prevent victims from testifying at preliminary hearing, my concern is that this is now a new avenue for defendants to say, well, I'm entitled to this hearing. And really the only, I think in most cases, prosecutors are going to have to subpoena the victim to testify to demonstrate that self-defense was not valid, is not a valid defense in that case. And I think it's going to open up a new opportunity for defendants to witness tamper, to pressure a victim to get the case dismissed by admitting that they were the initiator, they were the aggressor. And so, you know, the sponsor of this bill, Representative Lisenby, she cares about what victims think about her legislation and this one in particular. And she said she will come back next year if we can demonstrate that it's had a negative effect on domestic violence victims and, you know, amend it appropriately. So if you could monitor domestic violence cases, especially victim-related cases, and if you're noticing that these self-defense hearings are being requested, to give us a heads up so we can look into it and give her feedback next year.
So Heidi, more clearly, tell me exactly what you want us to monitor.
If defendants are requesting these self-defense hearings in victim-related cases.
Okay, so we can all do that, and we all need to do that. This is a scary one to me.
Great. Protective order revisions. As you probably remember, last year Representative Snow sponsored a bill that passed that combined all protective orders to try to make it a more uniform system so we don't have different rules applying to each of the various protective orders that we have in the law. This really is a tweak of that bill and trying to correct some of the problems that were noticed from that bill in the past year. There are a couple of things though that are notable changes. Some of the expiration dates for protective orders have changed slightly. Some of the time frames required have changed a bit. They've added sexual battery as a qualifying offense for a protective order. That's helpful. The big change, I think, is that the bill provides that jail release agreements, which, as you recall, are the little agreements kind of like a protective order, but it's issued by the jail. It allows someone to get out of jail if they agree to several different conditions, one of which is not having any contact with the victim. But those jail protective orders that we've had for a number of years now can be used before booking. So on a misdemeanor, a citation, for example, they wouldn't have to book them at all. They can issue a citation, but then also issue a what we call a jail protective order, even though they've never been to jail. So I guess the police officer is going to be given the authority to do that when he or she issues a citation. So that's a significant change. We'll have to take a look at that and see if that's going to cause a whole lot of disruption, but potentially could. It also changes slightly the waiver process, again, because the waiver now doesn't necessarily come from an issue of an order at jail. It could be from an order issued by a police officer on a citation. So that process has been slightly modified. I think the conditions are the same, but the system for doing it's changed a little bit. So anyway, that's one to watch closely and see what happens. Generally, Representative Snow is pretty responsive to problems. And if what he's done here creates more problems, I think he'll change it next year for us. Status on that one, let's see, that still is not passed. So it may not happen at all, but we're not sure, but it seems to be moving along.
Reed, and we had a request from Ruthie to review that again. Ruthie, do you just want him to summarize the bill again?
Yeah, I just had a question on, does that allow, it sounds like he was saying it allows for officers to basically issue a JRA?
Yes, on,
okay.
on a case where they're citing someone, not taking him to jail.
Okay, all right, thank you.
Let me check the status quickly and see if there's been any change since I looked last, and that may help us. It looks like it's in Senate rules. It was one of those that was put into rules yesterday off the second reading counter. So it hasn't, like the last one we talked about, made it back on the board yet, but it has gone through the House and gone through the Senate committee. So it's just have to wait and see if it has the oomph to get before the full body again. Okay, let's move on.
Okay, so this bill, wow, we separated these bills out early in the week to talk about. And after I started looking at this bill, I thought, yeah, I know why Reed and Heidi were so quick to say, this is yours, James. Kidding. This is 186 pages long, this bill. There's a lot in there. And quite frankly, I actually had another slide that's updated from this. Let me tell you what some of the high points that go on with HB 260 and what it does to restitution. It actually helps victims and it helps the Utah office, Rochelle's office, in being able to go after restitution as well once they've paid it. And it puts them as a victim for restitution. And it prioritizes, probably the biggest thing that this bill does is it prioritizes victims to be the first person that is paid with any payments made to a court. It prioritizes them above AP&P, above any fines or fees, that monies that are paid to the court go first to victims, which is a wonderful change. It also, as I mentioned, it provides reparations, which is really the Office for Victims of Crime, a better course to collect restitution. And it also provides that restitution and diversion agreements must be ordered by a court and the requirement to put restitution in plea and abeyance. What this bill is trying to do is push forward the time that restitution is determined. So there's a requirement on law enforcement to put in their report issues of restitution and trying to encourage them to make those determinations early. So they've got some new requirements that they will have to put in their reports that they're aware of restitution or they're not aware of it, but they will have to look at that issue as law enforcement right up front and hopefully be collecting that evidence and that information early and tipping off prosecutors and other folks who are down the line that there is restitution that should be considered in a case. It also requires prosecutors to make affirmations to the court to make confirmations that they have talked with the victim and that there is no restitution ordered before a plea is taken. So what we'll want to do as victim advocates is make sure, as you already do, that restitution is being considered by the prosecutors, that we're getting the information, and the courts are trying to move up. Well, this bill moves everyone up in time in determining restitution, including the courts. So there's one slide that's not on there, and I'll try to remember the details of it, but the courts are now required to determine restitution upon the completion of a sentence, or the earlier, if this happens earlier, 1 year for misdemeanors, 3 years for felonies, and 7 years for first-degree felonies. So a court can revisit that restitution in those timeframes. So now you can see there's a solid time frame for restitution to be considered by a court, either once the sentence is finished and completed, or within a year, whichever is earlier, a year on misdemeanors, or 3 years on felonies and 7 years on first-degree felonies. It also allows the Board of Pardons to make restitution orders and modify restitution. So those are the main things that this bill does. There's other things, but just know that everything's being moved forward, which is a great idea. I know on the Victims Council, going back to just years ago, we were hopeful that we could get restitution put in all negotiated settlements. So victims, we had a pathway forward knowing what was ordered by a court, and so we could proceed the best way we could with restitution. We still believe the earlier the better, and this bill kind of carries that into effect, which is a good thing. It's a long, long bill. Stay tuned.
James, in the chat, Marcy just wants to know, could this be a trick and you could just have law enforcement say there will be restitution in the report?
Law enforcement, if I pull up the bill real quick, I could answer that question.
Yeah, I was just wondering if that's enough in the initial report to say, you know, there will be restitution. Of course, that will be established as the case goes forward, but is that enough in the initial report? Or because they're not, like on that initial call, let's be honest, they're not going to know the restitution, right?
Yeah, let me pull up. It's House Bill 260. Hope you can still hear me because I've lost all visual. I was trying to pull up the bill so we could look at the exact language.
We can hear you and see you, James.
Can you?
We can come back to it too.
Let's do that, and I'll pull up the bill and give you the exact language of what law enforcement's to be looking at and what the prosecutors are supposed to do. It's in the same part of the bill.
And you guys I linked the 2021 legislative session, so you guys can actually type in and read that bill for yourself if you'd like to.
It's an awful lot of fun.
It looks like a good reading.
It will put you to sleep tonight if you have a little insomnia.
House Bill 289. House Bill 289 is Representative Lisenby's bill. It's kind of in the same category as several of the ones we've talked about today. It was sent back from the second reading calendar in the Senate to the Rules Committee. So whether it gets back out and is heard is kind of up in the air. It has passed the House and has passed the Senate committee, but is in rules in the Senate. The bill started out as an effort to suggest that we ought to combine victim services, state victim services around the state into one department. That generated a lot of discussion, which it was intended to do. And so that has been pulled back and will be left for discussion over the next year. So that's an interesting discussion that I think all of you are going to want to be involved in. It will involve any state agency providing victim services and whether we should combine them into one entity. And if so, should it be housed under the governor or should it be housed under the attorney general? But those are not issues in this bill at this point, but they will be things to think about over the next year. This bill at this point just relates to the council, the State Council on Victims of Crime. It adds 3 additional seats to that council, and it makes it clear that the council can be heard in appeals cases in conjunction with the governor's office. And it sets out some structure for the council by providing that A chairman should be appointed each year, elected each year, and a vice chairman, a secretary, and a treasurer. Those things are things that have been done already, but this puts it into statute and makes it a little more clear. So we'll see if it passes or not.
This is an interesting bill. Again, this is a picture from Utah. You can see that crimes against liberty. These are individuals who were marching against the state epidemiologist and actually appearing at homes of state elected officials. And you can see the Utah suicides 663, COVID deaths 659. But they were showing up at people's homes, which I quite frankly think is not very good form. This bill corrects that. We don't know if it's passed yet. It hadn't last night or this morning, but it creates the offense of targeting residences when you picket, and doing that with the intent to cause another to engage in targeted residential picketing. It makes it its own criminal offense. So that should be good. If we ever do something that people don't like, they shouldn't show up at your home and start picketing your home. Makes good sense. It's too bad we have to have a law to do that, but people haven't acted too rationally through COVID, quite frankly. And
it's now passed, James.
Okay, so that's a new bill. If you're aware of anyone of that occurring, that's can now be addressed in a criminal court.
Well, I'm so excited about House Bill 301. Even though Representative Perucci was the one that sponsored that stalking bill that we talked about that got defeated, this is actually very good for victims. This is called the Domestic Violence Training Amendments, and it specifically acknowledges and requires that law enforcement, as early as post-training and subsequent department training, they develop a curriculum specifically tailored to addressing issues of domestic violence. So if you read the statute, it gives a long list of all the presentation topics and training that the officers have to get, including being trained on the cycle of violence, on trauma, evidence-based assessment of lethality, indicators of strangulation, which I think are really important and often overlooked, trauma-informed interviewing, responding to the needs of domestic violence victims, that delivering services to domestic violence victims should be compassionate, sensitive, and professional, talking about domestic violence myths, and also requiring some data collection from the Department of Public Health and the Division of Child and Family Services. So I think this is just a great effort. I've been training at the Police Academy for over 20 years now. And even though they have some victim-related training, it's really been cut down over the years as far as how many hours we're able to dedicate up to that. And so this is going to increase that training. And what Marcy had commented on earlier about police officers responding to domestic violence cases, under 7736, the Cohabitant Abuse Act, it outlines how officers are trying to assess who the predominant aggressor in the situation is. And so this training will help reinforce those ideas that domestic violence is a unique type of case, that it requires really special insight and education about. And I especially appreciate the provision in there about delivering services to domestic violence victims compassionately, with sensitivity and professional. So I think this is a great bill. It sends a good message. Hopefully it will result in our officers being better trained on domestic violence response. And I think this is a really great movement for domestic violence victims. On the expungement amendments, House Bill 329, this also has passed. And what it essentially does is it allows either a defendant or a respondent in a defendant in a criminal case and a respondent in a protective order case, that if that case is dismissed or the protective order is denied, that the defendant can request to have their name and personal information delinked from that case. So right now we're able to search on the court's exchange program and see even when a case has been filed, even if it ends up being dismissed or denied. But what this would allow is for that defendant or respondent to petition the court once that case has been dismissed or the protective order has been denied, to essentially erase or delink their name from that case. So I guess it's a benefit for defendants when the cases don't go anywhere. It doesn't let us really know if there's been a history of other claims against that defendant or abuser. So it's not really a pro-victim change, but it's a change that might impact some of your cases.
$334 is now passed as well. It is another training bill. It requires that, well, it's actually a response to some of the high profile cases we've had in the state, police officers taking aggressive action against someone who's resisting arrest or resisting confrontations, and later on finding out that person has mental disabilities, autism, or other problems that have caused them to act the way they acted. So this provides that there will be mandatory training for all police officers in the state on mental illness issues and autism issues so that they can better respond to people with those conditions. The interesting thing about this bill is that rather than requiring one-time training in the police academy, it requires annual training every single year to every police officer. So it'll be interesting to see if that remains, but that's a lot of training. They are required in order to keep their license to have 40 hours of training every year. And now part of that 40 hours is going to have to be dedicated to this topic.
This is House Bill 373, the conviction reduction amendments. This is bills passed, and you're familiar with the 402 reduction. That is basically a defendant who's completed probation successfully can ask the court to reduce their sentence or the conviction of their felony offense or misdemeanor offense one level lower. That's always been available to those that have been given a probationary sentence. This actually applies to those who have gone to prison and not just jail, but now they can, once they complete their parole, they can go back and ask a court to reduce their conviction 1 degree. So I don't know that it's super victim friendly, but that provision is now given to individuals that have served a parole or served in prison and are now released on parole. This is my least favorite bill of the session so far. Well, I don't know if I can say that.
And by the way, it just passed, James.
Did it? Yeah. If we were in the same room together today, I'd ask how many of you have a camera at your front doorstep? And I would dare to say, how many do? I guess say, how many have a recording on their doorstep? Ring or some other?
Bottom of the screen, there's a little reaction and you can put a yes or a no in there or a thumbs up.
Oh. Yeah. Boy, look at all these new things we're learning on Zoom. Don't go steal things from Rochelle's house or Marcy's, or many of you have these security systems at your home now. This is kind of sad, actually. This it actually sets forth how law enforcement actually has to make application to apply to the state. They have this facial recognition technology, which is really wonderful. But now to be able to use it, it restricts it to a criminal investigation to a felony, a violent crime, or a threat to human life. So some of you may be ordering things off of Amazon that rise to, that are worth over $1,000, but most of us don't fall into that category. And so this would not cover being able to solve, use that technology to solve porch pirating, where it's not a felony level. So it will hamper that to some degree. I don't think that's good for victims at all. I don't think this is a victim-friendly bill in the very least. But maybe it's one that we can always go back to the legislature. We've got to keep that in mind. If we like something that passed, someone may come back the next year to try to undo it. But if something passes that we don't like, we can always try to come back the next year and fix it. This might be one that we really consider doing that for, because many of us, and Utah has more than its fair share. In fact, there's an article on KSL that talked about Utah being at the high end of having these types of thefts occur. So stay tuned. That's kind of bad news, but you may be able to put it out on social media and someone may be able to recognize that person, or law enforcement would, but we just cannot use facial recognition technology to solve those misdemeanor crimes at this time. This is a bill that there's always kind of been a problem, and many of us are aware of this, where a juvenile offender committed an act while they were under the age of 18, but we didn't find out about it until they were, say, 20 or 21, and then they're brought to the adult system. The juvenile system is set up to rehabilitate. Both systems are, but there's a lot more leeway and opportunity for an offender in a juvenile system to not be incarcerated for substantial periods of time. This tries to bring some evening to, if you're over the age of 18 when you were found out, that you're going to be treated more like you were as a juvenile offender. So this limits that a person who commits a sex offense as a juvenile is not tried until they are an adult. It limits incarcerations to 7 years for an sex assault case and 4 years for other sexual offenses. If they were an adult, they're subjected to much, much longer terms of incarceration. And it also sets forth that misdemeanor offenses they can't serve more than 364 days. So, and it also provides that the individual is not subjected to the sex offender registry. So those are just, it's trying to bring some semblance of fairness to those individuals that committed the offense while they were under 18, but they were found out afterwards, and still provide for some public safety. Anything you wanted to add, Reed or Heidi, on that one?
Oh, that was good. Gang enhancement bill. This started out as kind of a negative bill, I thought, and then still is somewhat negative. It has passed. It changes the requirement to charge under the gang provisions that you have 3 other people involved instead of currently you only need 2 other people involved. So it makes it a little tougher to use the gang provisions, which I think is a negative. They also initially were trying to make the determination as to what level of offense you charged under the enhancement a decision for the judge at sentencing. And we fought that. And so the compromise has been, it's still a prosecutor decision in filing the case to decide whether to use the enhancement or not. But they have put into the bill significant guidelines as to when you can enhance and when you can't. And if you do enhance, how much you can enhance. And that depends on the type of crime that is involved. Gang enhancements can be applied to a variety of different crimes if there were gang provisions, 3 or more other people involved. Now, what the crime is, it limits as it can be.
And I just want to acknowledge, I've been monitoring the chat, and I think there are a couple of questions on previous discussions that we've had that we can get to at the end. We're near the end of the formal presentation, but I just wanted to talk about Senate Bill 64. This is a pro-victim amendment to domestic violence statute. And it essentially says that on the 3rd domestic violence conviction, If it's a Class B misdemeanor, most domestic violence assaults are Class B misdemeanors unless there are injuries or a weapon is used. And so this makes the third domestic violence conviction a third-degree felony. Our other enhancement statutes typically just bump it up 1 degree. So if it's a Class B assault and you have a prior conviction, it bumps it up to a Class A. But this is acknowledging that if this is a repeat offender and there are 3 convictions within a 10-year time period, then it's actually in the felony range, a third-degree felony. So that's great for victims. Again, it has to be within 10 years that the 3 instances occur. But this is a good movement because we do know that domestic violence is a repeat crime. And this provides additional and more serious protections for victims and consequences for their abusers.
You know, the legislature's been real negative towards enhancements for the last number of years. Part of the JRI movement was to do away with most.
Well, that makes me super mad because let's be honest.
So this to take.
Like, how many dismissals or amendments are there before they're actually charged with that for the first time? So you know, 3 times, that equals, like, really in real life, that's like what, 4 or 5 different charges? I'm just saying, like, prosecutors always dismiss the first time. Anyway, so it makes me mad that legislation is so hesitant to enhance these because everyone's already getting a break. So sorry, I just had to say that. Sorry.
And Reed, you were cutting out. What was your comment, Reed? It was spotty.
Well, my comment was that the legislature's been really nasty towards all enhancements lately. And to get this one passed when they're eliminating them in other areas, I think is good. It may not be the best that you could get, but it's very good that they did it at all.
Well, I love the comments that we're getting in the chat. Alicia had asked, does it matter if it's the same victim? It does not have to be the same victim. And my understanding and the way it has always been, even when I prosecuted, was a plea in abeyance conviction, even though that conviction isn't entered, qualifies. Is that still true, James? Prosecuting? Oh, you're muted.
Yeah, I missed your question, Heidi.
Oh, even if they're under a plea in abeyance, that qualifies as a previous conviction.
Yes.
Right, in the 10 years. And it does not have to be the same victim. So, I love Caitlin and Marcy's responses that, you know, the fact that the legislature is reticent to do enhancements lights their hair on fire, and they get animated about this. But fortunately, you know, we as a victim community have been able to convince them that domestic violence is a repeat offense. I mean, sometimes it's an isolated incident, and you know, there's one violent incident and doesn't happen again. But true domestic violence, we know there are going to be repeat offenses, and even if they migrate to a different partner, that new partner is going to be in danger. And so I think this is a great bill to recognize that. So we've got a question here. Does this apply to other states if someone got convicted in California twice, but moved states and got convicted here? And I've got the statute in front of me, but I do think that it includes convictions. It doesn't have to be a conviction in Utah.
I believe that's right.
Yeah, but it would have to be an offense detailed in Utah, right?
Yes, so there is a list, and actually the statute excludes criminal mischief. You have to have the previous instances within a 5-year period if you're relying on a DV criminal mischief case, but all other domestic violence listed offenses, if there's a companion conviction in a different state, then it would qualify as a predicate offense here. Okay, great. Rochelle, you can move on.
These next two are two of my favorite provisions of the year. This one doesn't really have anything to do with criminal law, but it's a wonderful victim provision. What it says is that if a person is convicted of a felony offense against vulnerable adults, you can exclude that person from receiving any inheritance from that individual. And that can be physical abuse or financial abuse. So if a relative takes money from an older citizen, they illegally, they can be excluded from receiving any money from that person in their wills or in their trusts or through any other type of testamentary disposition. There are some exceptions, but the concept is really sound, and I think a wonderful change in the law that allows us to keep those people from receiving benefit from folks that they're treating badly. So a great provision. 124 is also a great provision. Hopefully it doesn't apply too much, but what it says is that a person who is in prison for homicide cannot be paroled unless they provide whatever information they can provide to recover the remains of the person who they killed. So if they won't cooperate in getting the remains back, they'll have to serve their full prison term and cannot be paroled. Good provision.
And Leah, I think this addresses what you had asked, and I knew that this was coming up. Leah had asked if we were going to cover this bill earlier in the chat.
Yeah, and that one has passed. So what sections with any of the bills, maybe?
Well, you guys are the most timely presenters yet. Look at that. Last slide at the 3 o'clock.
Yeah, Rochelle, it's so good to be with you today. I did have, if people want to look, I just followed up with that, what's required of law enforcement. It is in, and I don't want to go over, but if I share my screen here, it's right here. Well, it's 4212. So here's the provision that law enforcement, there was a question about what is required of them. And here it is. So a law enforcement agency investigating, it's here on the screen. Can you see that okay?
Yes.
That would constitute a felony or misdemeanor shall include all information about restitution for any potential victim in the investigative report, including information about whether a claim for restitution exists, the basis for the claim, and the estimated or actual amount of the claim. And then you can see what's the duties that are put on a prosecutor down below that files a charge. They shall contact any known victim of the offense for which the criminal charge is filed or person asserting a claim for restitution on behalf of the victim and gather the following information. We're already doing that, right, in most places, but I just wanted to follow up and answer the question that was asked earlier. And I don't want to be untimely. It's 3 o'clock, so I'll shut up now.
But James, we did have a question a while ago about the concealed weapons, about whether a business can prohibit weapons from being on their premise.
Good question. Reed is the gun.
General answer to that is the general answer to that is yes. If it's private property, they can restrict guns on their private property.
Yeah.
Now, how you enforce that, pretty tough. They'd have to have a magnetometer to check and see if they have a concealed weapon.
Are there any other questions?
I had a question, Heidi. On that restitution bill where it talked about parole having the power to amend a restitution order after the fact, what would be an example of what parole would be able to step in? I think it was just a summary, but like specifically, where would that come in? That would be where it would be helpful to victims when it's at the Board of Pardons and Parole level.
Yeah, if for instance, if restitution hadn't been ordered, they could issue an order there. I think that would be a time where it would be helpful for victims, that the parole board could issue a restitution order. before the person's released. So that might be a helpful provision. The other side of it, and I've worked in law enforcement long enough, I'm always suspicious, right, how it might be used, that they might try to upend a court's order of restitution, but we'll have to wait and see. But I do think, I know Clark Harms now works in my office, but that was something that he thought would be useful, is that the parole board could now issue restitution if it hadn't been issued before. But again, if they have that authority, and it's in the bill, I don't have the exact line. There's 156 instances of parole. But I hope that answers your question.
It does. And you have the same concern that I did as well. Could it be used to be amended the other way? Yeah.
So again, I so appreciate all the eyes and ears of victim advocates out there, that if there are these issues going on, to bring it back around to the legislative subcommittee. And we forgot to mention this earlier, Heidi and Reed are the chairs of that committee on the council. It's a subcommittee. It's a very active committee. They meet at least weekly and more often by phone with members of the committee during the session. But if there are issues like that, we have great allies with other agencies, the AG's office and Sheriff's Association and the Chiefs Association and others that are generally on the same page as we are. And so if you have other issues that you're seeing and there are problems with things that have passed this year or other problems with other bills, we solicit your participation. And quite frankly, when you get on the horn, or when you show up at hearings, legislators listen. They really do. They hear you.
Great. Thank you guys for being here. Don't leave yet. I'm just thanking our presenters. I'm going to give Hildy a couple minutes. We have National Crime Victims Week coming up, and so I want to give her time to let you know about that. So go ahead, Hildy. But thank you, James, Heidi, and Reed. We really appreciate you being here.
Thank you all so much. It was so informative and it's so important in this work. So thank you. And thanks for all the work you all do. I just wanted to quickly just talk about the National Crime Victims' Rights Week. It will be April 18th to the 24th. We have 8 events planned at this time. 2 of them will be for the whole week. And then we'll have one on a Sunday 18th, we'll have a candlelight vigil. On April 20th, we will be doing a podcast in collaboration with Alex Merritt with the Utah Crime Victims Legal Clinic. And then we will be doing 2 art events in collaboration with Unique Foundation and UMOCA, which is the Utah Museum of Contemporary Art. Then on the 23rd, we will be doing a town hall virtual event for individuals to learn about victim advocate and all the criminal justice system. And then on April 24th, we will be doing a film in collaboration with Netflix, and then we'll be doing a virtual panel after that. All these events are free of charge. And if you want more information, please do reach out to me. And then also, if I know that Rochelle has shared the flyer with y'all, so you're welcome to call me if you have any questions or if you'd like to participate in some way. So, and this is a whole statewide event, and it will be mostly all virtual because of safety. So.
Excellent. Thank you, Hildy. I mean, everyone knows I would like to end on time, but I knew that was important enough and I wanted to get it out there. So I really appreciate you all for sticking through it. Such an informative session and a lot going on, and, you know, just 96 of us on this meeting today, like victim advocates, if we all work together, sometimes we're going to change and have different opinions, and that's okay. But I think we could really have a very good unified voice about a lot of issues. So good work during this session, and we'll see what's coming up. Maddie has put the survey in the chat. If you can please fill that out for me, that's super informative. It helps my grant. I have to turn in my reports like a lot of you guys, and so that is part of it. So I'm going to stick around if you have any questions. It was great to see you all, and I look forward to seeing you next Thursday, and the next 3 sessions will be from OVC TTAC on collaboration. So thanks for being here.